Hello and welcome to Senior Living, the program of questions and answers for seniors and for the community at large. I am Lynn Brennan, your host, and today's topic is housing and the law. We welcome our very special guest and expert, Paula Gardner. She's the Executive Director of the Nebraska Equal Opportunity Commission. Welcome, Paula.
Thanks for having me, Lynn.
You're welcome. So, housing, how did it begin, or when and where? We could go all the way back to Adam and Eve when they were evicted from the Garden of Eden. They had to find housing.
And clothing.
Oh, that's right. Well, from there, flash forward many years. Near the end of the Civil War, President Abraham Lincoln signed the Homestead Act of 1862. The law gave over 270 million acres of land to Americans in 160-acre lots for a residency of 5 years and agreement to improve the property. So, we have a photo here. This photo was taken, of course, much later. But this is how many of us had our beginnings, particularly here in the heartland. After traveling across the plains in covered wagons of prairie schooners, they were later, over the Oregon Trail, called the Platte River Road through Nebraska. A total of 2,170 miles of travel. And as you can see by this map, what a journey. And I believe, Paula, you said your family still has their original homestead.
We do. We have the original homestead that my great-great-grandmother got when she came from Wisconsin to Nebraska as part of the Homestead Act.
Wow.
It's just here east of Lincoln.
That is great. And my grandmother's people came from Oslo, Norway in the 1860s and settled in Maskell, Nebraska.
Oh, okay.
Yeah. So, and for housing on these pioneers, first thing to do, what? Build a cabin. Or sod homes were some of the first dwellings for many heartland settlers. So, I know, Paula, you've done some research. Tell us more of the history of housing and the law and the developments and how the government got involved.
Yeah, so you mentioned the Homestead Act. And through the Homestead Act, the decades that the Homestead Act was going on, there's about 1.6 million individuals who are able to apply for that program and take advantage of it. But of those 1.6 million, only about 3,500 were black families. So around that same time of the Homestead Act was the end of the Civil War. And at the time, Congress enacted some amendments. They enacted the 13th, 14th, and 15th amendments of the Constitution, and that granted those freed slaves some additional rights that they didn't previously have. So they had all the rights and freedoms for the federal government, and also the rights and freedoms for the states, equal protection under the law, and even for the freed male slaves, they had voting rights as well. So while Congress was trying to ensure additional rights for the freed slaves, states instead were enacting what were called black codes. And what the black codes were doing were limiting or restricting those freed slaves with the labor they could do, activities they could do, and even in some situations, property that could be owned. So at the end of that century, at the end of the 1800s, the Supreme Court essentially agreed that there should be segregation. So in their finding in Plessy versus Ferguson, they upheld the separate but equal doctrine. So kind of fast forward a little bit now to the Great Depression. And during this time, FDR was looking for ways to help low-income families with home ownership. That was an important project for him. So they created the Homeowners Loan Corporation and the Federal Housing Administration. And these entities essentially perpetuated that separate but equal doctrine. So at the Homeowners Loan Corporation, they would create maps of cities to determine about mortgage loans and where the risk was in providing those mortgage loans. So in neighborhoods that were color-coded blue and green, that's where the European families lived, European descendants. There was Jewish families, Italian families, Irish families living there, and those were considered safe loans to make. There was low-risk loans that you would make in those neighborhoods. Then the neighborhoods that were coded yellow had a little bit more of a moderate risk, and that's where some of the working-class white families lived. And finally, you had the color red. And if you lived in one of the red areas, then that was too high of a risk, and you weren't permitted to receive a loan from the federal government for a home mortgage. And in those neighborhoods lived the Black and Hispanic families. So that's where the term redlining comes from. It's from that literal red line on those maps.
Oh, okay. Well, I know there was a lot of difficulties in, a birthing nation and all that was involved. And after all, we were just coming out of, freedom of, and that was Abraham Lincoln's endeavor for free country.
Yes.
For everyone. But we're here today to talk about the positive and how the government has improved housing and through laws and movements. And so carrying on from there, what about, let's see, the 50s and the 60s?
Yeah, so just right before the 50s and the 60s, because this kind of leads up to some of the reason why what happened in the 50s and 60s happened, is the Fair Housing Administration also created programs to segregate families. They said that basically racial groups shouldn't be living close together and suggested building highways in cities to create that barrier. And so you actually see that in Omaha with the North Freeway. That's what happened. So all of this is kind of building the segregation. The white families are moving away from the inner city, and the Black and Hispanic families are kind of being moved into the inner city. So in the 50s and 60s, especially in 1962, President Kennedy had an executive order. And in his executive order, he prohibited discrimination in federal programs and in federal land management programs based on race, color, creed, and national origin. And then in 1964, you have sort of the landmark civil rights passage of Title VII, Title VI, and Title VII, which prohibited discrimination in employment, public accommodations, education, and voting. So, but not included in that group was housing. So in 1966, Congress sort of took up that mantle and was working through considerations for housing discrimination legislation. And at that time, a report came out. It was called the Kerner Commission Report. And it really highlighted how these policies that were going on through the 20s and the 30s and the 40s were really impacting that racial segregation, and it was causing unrest during that time. And instead of it being separate but equal, it was very clear that it was separate but unequal, particularly with regard to housing and education. So while the bill was passed in the Senate, it was at the House in Congress, and the Reverend Dr. Martin Luther King Jr. was assassinated.
That's right, and that was 1968,
yeah. April 11th, 1968. And within days of his funeral, it passed in the House, and President Johnson signed into law the Fair Housing Act. So initially, the Fair Housing Act prohibited discrimination based on race, color, national origin, and religion. In 1962, they decided to add in sex as a protected class. But it wasn't until 1988 that they also included families with children and individuals with disabilities.
To bring it up to present then, tell us, what is the Nebraska Equal Opportunity Commission?
Yes, so the Nebraska Equal Opportunity Commission was established in 1965. So that you'll notice that's around the same time that all these laws were being passed at the federal level. The unicameral decided that they wanted to have laws specific for Nebraska to protect Nebraska citizens. So they established the Nebraska Equal Opportunity Commission and passed what was called the Nebraska Fair Employment Practice Act. And that act essentially mirrors Title VII of the federal civil rights laws. Then in 1967, they passed the Equal Pay Act. And in 1969, they passed the Civil Rights Act. And contained in the Civil Rights Act was discrimination based regarding public accommodation and housing. So at one time, those two ideas were together in one law.
Oh.
Then in 1972, they passed the Nebraska Act prohibiting unjust discrimination, employment because of age. Fortunately, many years later, they changed that name to the Nebraska Age Discrimination Employment Act. They shortened that title. And then in 1991, they sort of extracted the fair housing statutes out of the Civil Rights Act and created its own separate statute, the Fair Housing Act. So those are the statutes that our agency has jurisdiction over. The NEOC is what they call a quasi-judicial agency. So we have the authority to take charges of discrimination, conduct investigations based on those charge allegations. We are able to render determinations. We try to facilitate resolution to those charges informally and voluntarily. And we also provide education and outreach to the community, to individuals, to entities, whoever might want to have that information. So we are, as you know, a commission, and our commissioners are appointed by the governor. We do have 7 commissioners.
Of which I am one.
You are one of our commissioners.
And you are the executive
And
director.
I am the executive director. So the commissioners then in turn hire the executive director to run the day-to-day operations of the agency.
Well, and a lot is involved that you do and that you're responsible for. Because, my first question, does every state have an equal opportunity commission?
They do. Every state does have a civil rights agency. The District of Columbia also has a civil rights agency. And in addition to there being these agencies at the state level and the federal level, because we have the Equal Opportunity Commission and the Housing and Urban Development, there's also local municipalities that have some civil rights agencies. So in Nebraska, we have the Lincoln Commission on Human Rights, and in Omaha, we have the Human Rights and Relations Department.
And how do they relate to the NEOC, or do they?
So we work collaboratively. They have very similar laws to the state laws and to the federal laws. So they're able to also investigate charges and claims of discrimination within the confines of their city limits. So oftentimes, these city entities have kind of a lower threshold for being able to file a charge. So for instance, under state and federal law, an employer needs 15 or more employees for us to be able to do anything. But with the cities, that's below 15. So maybe you aren't able to do something at the state or federal level, but you might be able to find some relief at the city level.
Okay, that's interesting. And you mentioned the unicameral. It might be good to mention now that this is unique in the entire country, are we not?
We are. Nebraska has what's called a unicameral. So our legislature is just one body. It's one house. It's nonpartisan.
Okay, so what I would like to ask you too now, what does one need to know or need to do to file a complaint? Say if I'm a person in employment and I'm over 40 and I feel that I've been discriminated against or forced to resign because of my age, what would I do to actually have a valid case, for example?
Well, the first thing we would want you to do is to contact our agency and to speak to one of our investigators. And the investigator can ask a series of questions to determine if, one, you're a member of a protected class, so in this situation, that you're over the age of 40, and that some action was taken against you. You were terminated, you weren't hired, you were forced to resign, and that there's some connection between those two things. There's a connection between your age and the action that was taken. So once that's established...
Now let me interrupt there, because I think for the complainant, it might be important for them to realize that they need to have that connection and to actually establish it within their employment. Is that correct?
Well, yeah, so what we would be looking at then during the investigation after that charge is filed is we would go to the employer to see what they have to say, what their reasons are for what happened. And then we get some additional information from the complainant and some evidence. That evidence might be how were other people treated in the same way.
Mm-hmm.
So for instance, you were terminated because of your attendance, and you believe that younger people who have the same attendance issues weren't terminated. But through that investigation, we might be able to determine, well, the employer was able to show through documentation that it treats everybody equally, and thus younger people were also terminated for attendance. But you coming to us, you might not know that. Your perception might be a little bit different. The investigation can help kind of clarify those things to help us make a determination about whether the agency believes discrimination did or did not occur.
And so to constitute a valid complaint, then I would want to, for example, address the employer and say, this is what's happening to me, and I believe that I'm being discriminated against. In other words, establish your case before you.
Well, that's especially important with harassment and the way the harassment laws have played out. So the harassment laws essentially require you to put your employer on notice that you believe you're being harassed based on a protected class, and then give the employer an opportunity to remedy that situation to ensure that it's taken care of and it doesn't happen moving forward. So you always want to try to resolve things with your employer, with your housing provider, prior to coming to us, because sometimes things are misunderstandings. Sometimes they can rise to the level of discrimination.
Well, it's very interesting, and it's three things that the NEOC deals with, right?
Mm-hmm.
Employment, housing, and public accommodation.
Correct.
So public accommodation is an interesting one because that could mean that I'm out at a restaurant and I feel that I was not treated properly, and so I could file a complaint, right?
Yeah, so it's pretty specific to be denied a service, but sometimes that denial of service can look like being seated at the restaurant, but then being completely ignored at the restaurant. So
well, that happens.
So that it has the effect to discourage you from receiving that service from that restaurant. So we don't see today, fortunately, a lot of reasonable cause public accommodation cases. Some that come to mind in the recent past have had to do with individuals in a banking situation where the teller, whoever they were working with, made assumptions about them based on their race or their national origin and held them to standards that they didn't hold people who were of a different race or national origin. So for instance, we have somebody who was trying to open an account. They had a social security number. They were here legally, but the teller made the assumption that that wasn't the case and took them down a completely different path, which prevented them from opening the account that they wanted to open, for instance.
Oh, that's interesting. And so as far as the NEOC board or commission, what they do is they read the investigative report, and then sometimes the complainant or the respondent or both will appear at the meeting, and however the decision has already been made, correct?
Well, there's recommendations are made, but ultimately the final decision rests with the commissioners, and that's with regard to age complaints, housing complaints,
right,
equal pay complaints, and public accommodation complaints. So the executive director makes the final decision for charges filed under the Nebraska Fair Employment Practice Act. So the commissioners have the investigative information, and sometimes it's helpful when the complainant respondent is there to help provide clarification, to answer any questions that the commissioners might have.
Right.
And then at the meeting, based on the totality of the information, the commissioners render their decision. And so I think that you would find, whether it's at the local level, the state level, or the federal level, a majority of the claims are probably no reasonable cause. Now, that doesn't mean that it's perfection in that situation. Oftentimes things could have been better and handled better by both parties, but it just doesn't rise to the level of illegal discrimination. And we have to get to that threshold based on what the courts have told us is necessary to be able to render a decision of illegal discrimination.
And you have said before that even though it could be no reasonable cause, still you feel could be a benefit in the process.
I do. I feel that there's benefit in the process. So
for both sides.
Yeah, so the complainant has an opportunity to be heard. And like I said, not everybody behaves well and properly in employment and housing and public accommodation situations. So they have an opportunity to show the employer, this happened to me and this is how I felt about it. And the employer then has an opportunity, even if they didn't engage in illegal discrimination, to kind of look at their policies and practices and try to be better. So that's part of our education and outreach. We will have employers and housing providers reach out to us because they want to be better and to learn more about how they can be a better landlord, be a better employer, be a better service provider. And we also give parties the opportunity to resolve their complaints through informal, voluntary settlement discussions.
And so they have another option afterward, do they not, if they don't agree with the commission's?
In employment, if a federal charge was filed as well, they can request that the EEOC review that investigation, and the EEOC may render a different decision, or they may agree with us. But regardless of what our agency determines, a person retains the right to file in court. And so that's important, because while our commission may make a ruling in one way, the court or a jury may find something different. So what our agency does is sort of help filter through all of the claims that could go to court. Because if everybody went to court with every complaint that they had, it would be 20 years before they had a chance in front of a judge or a jury.
That's right.
So we're able to look at those situations and render decisions and provide evidence to the parties to see if it's something that they really do want to take forward into the court system.
So it's a great community service that we provide.
I think so. I think so.
Oh, good. Well, yeah, and it's an honor to serve as well.
Well, we appreciate your service, because you certainly don't get paid a lot of money to be a commissioner at the NEOC.
That's true.
It's about the passion.
So let's move from there and talk more directly about housing and today, like buying a home, for example. So as an agent myself, I can address that a little bit as far as the law and for example, a purchase agreement, for buying a home, say here and I've been in California. It seems every year it gets longer and longer. It's like 16 plus pages.
More protections for the parties as it goes on. Yeah.
Exactly. So, and then all of the the forms that are required after the purchase agreement. But it's an interesting process, and one of the things that I have an article from the Real Estate Commission about love letters, and these are not love letters to your husband.
Right.
So let's talk a little bit about what they are and what they do.
So a love letter is something that a potential buyer might send to the seller to let the seller know that I'm really interested in this, especially in the housing market where there's not a lot of housing available. They maybe do whatever they can to kind of get their one up on anybody else who's wanting that house. And in that love letter, for instance, let's say I was writing a love letter and I might say, I would love to live here. This is perfect for my family. It would, the house is just set up right for my disabled child, and it would mean everything for us if you would consider us for this house. And there may be somebody else who provides a love letter, and maybe this other family who's looking to purchase the house is a retired couple, and they share how much they enjoy the neighborhood and walking the neighborhood and would really love to live in that house. Well, you need to be careful as the seller that you're not using those love letters to make your decision. Because if you're thinking, well, I don't know if this young family with this disabled child will fit into the neighborhood, but this older couple, retired couple, will fit in much better. And if you're making your decision based on that, you may be making your decision based on a discriminatory reason, because I am somebody with a family with a disabled child, and both of those are protected classes under the Fair Housing Act. So you want to be careful that whatever you do in any transaction that you're making, including selling a house, that you're making your decisions on non-discriminatory reasons.
Well, and again, let's put forth the areas that are possibly areas of discrimination.
Yeah, so in housing, it's race, color, national origin, disability, sex, familial status, and then there's retaliation. So if you engaged in a protected activity, so you filed a charge with the NEOC, and after you filed the charge with the NEOC, your landlord took some action against you, you might have standing to file a retaliation claim as well. So on the employment side, you can file on the basis of race, color, national origin, religion, disability, marital status, retaliation for having engaged in a protected activity under the law, whistleblower retaliation, or wage retaliation. I just want to back up. I think I left out religion when I mentioned housing.
Oh.
That's included as well.
That's a big one. Okay. Well, this has all been really very interesting about housing, you know, and the history, the law, and how it has progressed and progressed.
Yeah, so sort of, you know, the mission of the NEOC is to eliminate discrimination in Nebraska, and while we've certainly made progress, we're not there yet.
No, definitely not. I mean, we're all human, and you know, we fail all in many ways, and in particularly things like this, and also local jurisdictions can impact the housing market extremely. For example, in California, so many, like when I came here and I bought a townhome and I wanted to buy a new toilet, so I said, oh, do I have to buy a low flush toilet? Because that was the law in California.
Oh, yeah.
And so many more. So it's pretty interesting locally how there is a local involvement in.
Yes. There's lots of layers and things to know in all transactions, including the discrimination laws.
Right,
Yeah.
including buying a home.
Yes.
We've covered a lot, as I said, and you're such a great expert, and I really appreciate your involvement. How long have you been with the NEOC?
I've been with the agency for 25 years.
Wow.
Yeah. Started as an investigator and kind of worked my way up, and I've been the executive director just for about 18 months now.
Started when you were a teenager.
Almost.
Well, thank you. Thank you for your great input today. We really appreciate it. And this has all been great and informative, and we hope that you've all learned out there, and you know now that a complaint can be filed and will be addressed.
That's right. It'll be addressed.
So, thank you for your input, and thank you for watching this issue of Senior Living. Please join us next time for another important topic of interest. So until then, till we meet again, this is Lynn Brennan saying goodbye for now, happy, healthy aging, and God bless.